comes up and the witness is on the stand and the prosecutor says, "Now ma'am, would you please look around the room, tell us if you see the guy who raped you." And the witness on the stand looks over at your client and says, "That's him. I will never forget that face as long as I live." Right? Anybody have that experience on this rape? Right? How does that feel at that moment? Yeah, what do you want to do?
Crawl into the chair.
Crawl into the chair, walk out of the courtroom, right? It's just such an incredibly powerful, horrible moment during the trial. And yet it's such bullshit that it should be. But wait, back in 1982, Justice Brennan said that there is nothing more convincing than a live human being who takes the stand, points the finger at the defendant, and says, "That's the one." It is so, we know that it's so convincing to the jury, even though, of course they're going to point to your client, right? They've already picked him out of a photo array, right? He's the only one sitting at the defense table. It shouldn't mean anything, but it's such a powerful moment. And what we now know from the DNA exoneration cases, and there are now, last I checked, according to the Innocence Project website, 267 post-conviction DNA exonerations. And it's about over 75% of them involved at least one witness, and in some cases, multiple witnesses who made an identification of the defendant. And of course, they're always confident that that's definitely the guy. I'll never forget the face. And the problem is, what we have now learned, there are many great things that have come out of the work that the Innocence Project has done, but we have sort of been able to do a post-mortem on these cases and figure out what went wrong, right? How did this happen? Why is this happening? What's the problem? And what we are learning is that jurors just have fundamental misunderstandings, misconceptions about memory, about identification evidence. There are certain things that they just don't understand, and they're almost counterintuitive. And so what I want to do is first talk about what are those fundamental misunderstandings, because we have to know what they are in order to know how to deal with it when we get these cases. All right, so let's talk about these common misunderstandings. If you can't read it, it says, "We haven't reached a verdict, Your Honor, but we decided where to go for lunch." Okay? Our jurors aren't always the most intelligent people. They don't keep up on the social science research. Okay, so let's start looking at some of these. This is a study from 1992 that shows that there is a statistically significant difference between what experts in this area know and have found to be the case versus what jurors think regarding the influence of lineup fairness, regarding the effects of warnings, instructions that are given to the eyewitnesses before they're asked to make an identification, regarding the effects of show-ups, the influence of exposure time, that the jurors don't understand the forgetting curve. And we're going to talk in more detail about a lot of this stuff. Jurors don't understand the problems with cross-racial IDs. They don't understand that there is a lack of correlation. This is one of the biggest ones between confidence and accuracy. This is a study that was Public Defender Services in DC had, hired some sort of outfit to do a study of their jurors to figure out what their jurors think about these various issues. And they learned that jurors misunderstand the impact of stress, weapon focus, that jurors don't understand that people's estimates of time are not accurate, the confidence, accuracy, correlation. Jurors have misunderstandings about police eyewitnesses. We're going to talk a little bit about that as well. The difference between sequential and simultaneous lineups. They don't understand the importance of doing double-blind procedures. 51% of the people that they polled thought that an identification was more reliable if the witness wasn't giving warnings. We can talk about what some of those warnings are, right? That they weren't told that the suspect may not be here, that they're going to continue the investigation whether or not they make an identification, that type of thing. 51% thought it was more reliable if there wasn't such a warning. That's pretty scary, okay? Judges are ignorant about this, okay? Really ignorant. There was a study done in 2004, this was published, which involved 160 judges, mostly state, a few federal, a few retired, and one Indian tribal judge. And this is the breakdown. This is actually the most shocking part of this slide. How many, that 26% of these judges were former defense attorneys. I don't know where these judges are getting on the bench from the defense side, but they're not getting on the bench that much in Massachusetts. Witnesses' confidence at trial, they thought that was a good accuracy predictor. Is that a good accuracy predictor? Only 33% disagreed with that. Okay, 67% of these judges agreed that a witness's confidence at trial in the identification is a good predictor of the accuracy of that identification. Okay, these are judges. It's significantly harder to identify somebody who is wearing a hat. Only 45% agreed with that statement. And as we're going to see, okay, that is true. A witness's recall of minor details, and this is an interesting one, is a good accuracy indicator. Only 24% disagreed. That doesn't surprise me at all, right? A witness's ability to recall details of the crime scene, for example. I think most people would think, oh, if they can recall what the alley looked like, what color the garbage can was, then they're probably more reliable in identifying the perpetrator. Okay, turns out that's actually false. Turns out it's the opposite. We'll talk about that. So judges are really ignorant about this stuff. So let's talk about some of the specifics. Okay. Eliciting elaborate verbal descriptions leads to more inaccurate details. So you have a cop who says, okay, can you tell me what the facial features were like? Can you tell me what kind of jewelry the person was wearing? How tall, how heavy, right? What color pants were they? Were they shorts? Were they long pants? What happens is witnesses they think they should answer these questions, and so they come up with answers that are not accurate. Very interesting. We normally think of that as good police work. They're asking lots of questions, they're eliciting all the details. Okay, in fact, it can lead to a description of the perpetrator that is not accurate and may, in fact, lead to them arresting your client because your client fit that description, which was not truly the witness's memory. Okay? This is the one I mentioned before. There is a negative relationship between a witness's accurate identification and their ability to recall other aspects, details of other aspects of the crime scene. That's the person in the alley who can tell you the color of the garbage can that was nearby. Okay? There's actually a negative correlation between that and the ability to accurately make an identification. What it really indicates is that they are paying attention to other stuff and not actually to the face of the person who was robbing them or whatever the crime was. Weapon focus. Probably most of you have heard of this, right? The accuracy of an identification is reduced when there's a weapon involved. Witnesses look at the weapon. Why? Because that's the thing that's going to kill them. So, but this is counterintuitive to what our jurors think. They think that if there's a weapon involved, they think that if it's a stressful situation, people are more alert. Right? This is different than everyday life. This has never happened before, so I'm going to really pay attention to this person. That's what our jurors think, and it's absolutely not true. This is the same thing with stress, right? Stress leads to less accurate, less reliable identifications. This is a pretty interesting study that was done. Somebody mentioned this, I think, in a lecture the other day. What they did was they subjected people in the military to food and sleep deprivation for 48 hours. And then they had them undergo an interrogation. And some of them were considered high-stress interrogations, and some of them were low-stress interrogations. 24 hours later, they showed them a lineup to see if they could identify their interrogator. And the people who were subject to the high-stress interrogation performed much more poorly. They were much less capable of making an accurate identification. So that's a good study that shows that the effect of stress. It's also a good study, I think, to show that quote-unquote trained observers are no better at this than civilians. There's this notion. You guys have drug cases where police officers do these. In Massachusetts, they call them buy and walks, where they make a buy from somebody on the street. They don't arrest them right away. They walk away. Maybe another cop comes up and approaches somebody that's supposedly the seller, takes their picture, and then they show that single photo to the cop. The cop says, yeah, that's the guy who I bought from. People have those kinds of cases, right? These can be ID cases. If you go to trial, you may try this as an ID case. And this is the most incredibly suggestive identification procedure you can imagine, right? This would never fly if this were a civilian witness, to walk up to a civilian with a single photo and say, is this the guy, right? The cops are trained never to do that, or at least they should be trained never to do that with a civilian. But for some reason, judges think there's no problem doing that because it's a police officer. And I fear that our juries think the same thing. They think that cops have superhuman memories, that they are not subject to the same kinds of influences as civilians. It's just totally untrue. And the study I mentioned before, I think, is useful in trying to educate judges about this, because although it didn't involve police officers, it involved people in the military, people you might consider, quote unquote, trained or professional observers. So there's also a section in Elizabeth Loftus's book, which is a terrific book, Eyewitness Identification, which talks about the fact that police officers are no better at making identifications than civilians. This is interesting, that study that's perhaps useful as well, in which police officers, showing that police officers misunderstand these factors that we've been talking about, just like our jurors misunderstand them. They don't know all of these phenomena. By the way, please stop me at any point. There's a lot of material, so I'm kind of going fast, but please stop me at any point with any questions.
How do you get that in? The part about the trained observers are less reliable.
Well, I mean, we're going to talk about this, but so it may be that you want an educated judge at a motion to suppress, okay? I know in Massachusetts, we have judges who won't even give us hearings when we file motions to suppress, when it's a police officer who made the ID. So I'm going to at least cite to these studies to the judge to show him they're no different than anybody else. You have to at least give me a hearing on this. At a suppression hearing, maybe you can, introduce it, or at least file it, attach it to your memorandum, because then it's at least in the record when it goes up on appeal. And then if you're talking about a trial, educating jurors, I mean, there's a number of ways to do it, but you probably going to need an expert to talk about the actual research. Okay, you're not going to just be able to introduce a study. You're going to have to hire an expert to testify and to educate the jury. There are other things you can do in cross-examination of the cop in order to show the jury that he's no better than any civilian, right? When you were a hired officer, did they give you a memory test to test if you have good memory, short-term memory, long-term memory? You have to know what kind of qualifications there were, but in all likelihood, that's not part of their qualifications. It's not part of their training to see if they can, if they have better memory than other people. So you can cross them on the fact that they're no different than anybody else. You know, and they will acknowledge that they're human beings. They make mistakes sometimes. You can ask those questions on cross-examination to show the jury exactly that. These are people just like you and me. Yeah.
Well, have you had any problems getting a judge to allow expert testimony on just sort of a standard identification procedure?
At trial?
Yes.
I mean, you know, I've only had one trial where I've decided to put an expert on. The case ended up pleading at trial. We had an expert. He was there. The judge, I don't think, it was a good judge. I don't think she was going to shut us down. But some people definitely have had difficulty convincing judges. And the way you do it is by showing them those studies I talked about earlier that shows that jurors don't understand, that jurors do not understand these concepts. I'm going to come back to this again, but you have to be, if you're trying to either get funds for an expert or put an expert on, okay, do people here have difficulty even getting funds to hire these experts? Okay, you've got to be very specific. You can't just say this is a case about identification, I want an identification expert. You've got to say this is a case that involves these three phenomena that are misunderstood by jurors. It was a cross-racial identification. The perpetrator was wearing a hood and whatever the third, and there was a weapon involved. And each of those areas that impacts the reliability of the identification has been studied by social scientists. And here are the studies. It's part of why I'm going to give you these PowerPoints. You can find the studies yourself. Here are the studies that show that a cross-racial identification is less reliable. That one judges know about at least. But they don't necessarily know that somebody wearing a hat, it's the fact that the perpetrator is wearing a hat means it's harder to make an accurate identification. So here are the studies that show that, Judge, and here are the studies that show that jurors don't know this, and in fact sometimes think the opposite. So you have to educate the judge about what the specific factors are in your case, and the fact that those factors have been studied and that they're not understood by jurors, and therefore it's beyond the ken of the jurors, and it's something that will help them get to the truth. So, but I see too many people filing just these two general motions, saying it's an ID case, I need an ID expert. Okay, lighting can affect reliability, and maybe you hire somebody who understands the biology involved in vision and how lighting affects vision. That could be an expert that you might hire, depending upon what the lighting conditions are, to help educate the jury about how lower lighting impacts vision and impacts your ability to perceive. This is really fascinating, okay? We sort of all understand the general concept that it may be harder to make a reliable identification or to perceive what a person really looks like from a distance, okay? But this guy, Jeffrey Loftus, who I think is out in California, has done some very powerful stuff. He can actually replicate for a jury what somebody's face would look like from specific distances. Here, so let me show you this. Okay, this is a picture of somebody at 134 feet.
Is this an assumption of 20/20 vision?
What's that? It may be. I don't know.
It is. He's from Seattle, and I'm working with him now. And
Oh,
so when
okay.
he does that, it is based on that.
Okay. Can you tell us a little bit more about how he does this?
Well, it depends. I'm using him now on a cross-racial identification. And so he is, I haven't just hired him a couple weeks ago, but I've seen him testify before, and it's just the only thing that I find that's a little bit, I don't know if Miguel has used him before, but he's really well known. I think he's at the University of Washington, so all of our
Oh, is he
judges.
in Washington?
Yeah, all of our judges kind of know him already and stuff, but I think that overall we've gotten good results in it, but I can't tell you how he does it because I haven't really been able to see what he does, and he's great. He gives you the entire questions for direct examination and writes them all out for you, and he literally just sends them out to you, and I've met with him, so he's really good.
And there are lots of these experts now that know that know this whole area, and they can testify to all of these different phenomena. Some of them have studied specific phenomena more specifically, and those may be the people you want to get if that's the issue in your case. But he's done this very interesting work on distance. So any guesses about who this is?
Jackie O?
It's a woman, Jackie O.
Julia Roberts.
Usually
We got Julia Roberts. I thought Michael Jackson. Hey, can you see it? All right, so now here's 100 feet.
Yeah, Julie Roberts.
5 feet.
Yeah. Wow, that's good.
All right, now here's one from somebody's case. All right, this was the defendant, I believe, from 20 feet. Here he is at 100 feet. Here he is at 271 feet, which must have been the distance that the witness was. Right? Imagine showing that to a jury. Okay? How quickly can you say not guilty with that? It's such a powerful piece of visual evidence, as opposed to just having somebody on the stand or making the common sense argument that it's hard to see somebody from a distance. Now, obviously you need an expert who understands and can lay the foundation for how this is done, and how we can know that this is actually what this person would look like from that distance. And I don't know how it's done. So if you're going to do this, most of my cases I don't have, my witnesses are 2 inches away. So I don't have this issue in my cases. But was there a question? Somebody have a question? Cameron, did you have a question?
Yeah, I had a question. The facial recognition aspect from a distance is, I can easily understand that. But whenever the victim says, I saw, a shorter guy and a taller guy, and these were the clothes that he was wearing, and then the police find that guy, of the 2 guys, facial recognition doesn't really help me in a situation like that.
Because what they're describing is
Right,
the club.
yeah,
They're
like
not
the car,
describing
like says the car was
Right,
this color,
but there's still
2
gonna
guys.
there's still probably going to be an identification, and the identification is generally done by showing them a picture of somebody's face.
Right.
Right? So,
Show
in a case like that, you've got the great fact, which is there was no description of the person's face, right? And in a case like that, you may want to, on cross-examination of the police officer, make him look like he was doing the good police work I talked about. Now, you were careful in how you interviewed this witness, and you knew it was important to get as many details as you could about the robber's appearance. So you asked him about his clothing and his height and his weight, but you also asked him about what his face looked like, what race he was, whether he was light-skinned, dark-skinned, whether he had whether he had any noticeable scars or tattoos, right? So you can get the cop, because they're going to want to show the jury, I'm a good cop, I ask all the questions. Cop will buy right into that, and then and the only thing the person was able to describe were color of clothes and height.
Height.
The person said nothing about what this person's face looked like.
Right.
And then they were identified,
To show up.
and then you showed them a bunch of faces. Well, if it's a show-up,
Show up.
yeah. So, but, I mean, you see the point is, that's a good fact in that case, that there was no description of the face. And you can argue, they obviously didn't get a clear look at what the person's face looked like. Okay, and your client was just picked up because he sort of matched the description and happened to live in that neighborhood or whatever it is. All right? Duration. Okay, witnesses frequently overestimate the length of an event. Okay, how long they were talking to somebody. And the police and the prosecutor will try to stretch the amount of time that the witness or the alleged victim and the perpetrator interacted, right? Because that means they have more time to observe. We're going to talk about ways to shorten that in terms of cross-examination. But, and the greater the stress, the greater the overestimation of time. And this has also been studied. So, you may need an expert to explain this to a jury. Jurors don't necessarily know this. I've mentioned this before, but if the perpetrator is wearing something covering his hairline, that makes it more difficult for the witness to make an accurate, reliable identification. That's because the way we recognize people is by sort of looking at, taking a holistic view of their face, of their head. And hairline is very important to having that holistic view. And if somebody's hairline is covered, it's much more difficult to recognize the person later on. Okay? That is definitely not something that jurors know and understand. So in this case that I mentioned earlier, where we had an expert ready to go, that was one of the issues. And there was it was a robbery of a convenience store. And, you could see that the person in the surveillance video had a hood on, covering his head, covering his hair. So we had an expert who was going to testify to several different factors, including this one. Okay. Witnesses incorporate misleading features provided by other witnesses. Okay? That's something you have to be aware of. That a witness who hears other witnesses give descriptions may incorporate some feature that the other witness described into their description. And the police can also lead to that type of taint of their memory. Right? That's the last point there, is that if the police are questioning the witness and they suggest some feature, that can then become part of the person's memory. Took you a moment there, huh? My favorite part of this is the fact that whoever was watching this realized how hilarious it was and took the picture. I think Channel 7 got a few calls that night. You know, like, the misconception is that resemblance to a composite sketch indicates that the person is indicates a greater degree of reliability in an identification, right? So the witness sits down with a sketch artist or one of these computer programs. They generate a composite sketch, and lo and behold, your guy's arrested because he looks like the sketch. Okay, and people think that indicates a greater degree of, and then there's an identification that's done. Okay. The problem is the sketch itself alters the memory of the witness. Okay, the witness sits down with the sketch artist draws the picture of, and then that picture becomes, in the mind of the witness, becomes what the guy looked like. And it may not be accurate, And so, yeah, when your guy gets picked up because he looks like the sketch, and the witness sees your guy in the photo array and picks out his picture, it's because he looks like the sketch. It's not necessarily because he looks like the perpetrator. But people think that that's an indicator. I mean, that's a tough one with the jury if you've got one of these. He picked out the guy, and he looked like the sketch. Jurors think that means more reliable ID. Okay, transference, right? Sometimes you have cases where your client has been in the store before, where the convenience store that was robbed, and the clerk, when presented with a photo array with your client's picture in it, sees it and recognizes him, and thinks that's the guy who robbed him. When in fact they're remembering your client from some other time he had seen your client. Okay, that memory was transferred. Okay, the warnings I talked about earlier, when they sit down and do the photo array and they tell the witness, the person who robbed you may or may not be in this photo array. The studies have showed that giving these types of warnings leads to fewer false identifications. And as I said before, jurors don't necessarily know this, nor do judges. So the warning is important. Okay, this is like a model warning. This is what they should be doing. The perpetrator may or may not be present in the lineup. You should not feel like you have to make an identification. It's just as important to exclude innocent people as it is to identify the perpetrator. We will continue this investigation whether or not you pick out any photographs. And it's also important where the person who is doing this doesn't know the suspect's identity. That is a double-blind procedure. Okay? This is what we should be looking for, and when they're not giving warnings like that, here's cross-examination for you. Right? Officer, you never told the witness that you would continue the investigation even if he or she didn't pick out a photograph. Right? And when you have crossed the victim about the fact that the victim wanted to make sure this person was caught, didn't want this person to go free, didn't want this person to harm anybody else again. Now you have shown the jury that this is somebody that wanted to make an identification, that wanted the investigation to come to an end. And where the police officer didn't tell this person, we're going to do this, we're going to keep investigating whether or not you make an ID. Now you've set it up where this person felt like, okay, here's the chance to bring closure. Here's the chance to get somebody off the street that I think's a bad guy. Okay, the concept of relative judgment is very important. When somebody is shown a lineup, shown a photo array, okay, what they're often doing is picking the person who looks the most like the perpetrator. And you can often get witnesses to even say this. If you have a motion to suppress hearing, we're going to talk about that a little bit later, but if you have a motion to suppress hearing, you can try to lead the witness to say, and you looked at those photos, and you were looking, and you picked one out, and you picked that out because that person looked the most like the one who robbed you, the guy who robbed you. Sometimes a witness will say, yeah, that's what I did. Now you've got it, you've got a transcript of that hearing, and now you're going to be able to do that at trial and tell the jury, this was not somebody who is searching deeply in their memory for the face of the for exactly what the perpetrator looked like. This is somebody who is playing a game of multiple choice. Okay, which one looks the most like the guy who robbed me? It's this one. And yeah, my client may bear some resemblance to the perpetrator. That's why he's sitting here today, not because he was the robber, because he just looked something like the robber, more like the other 5 guys. And, you know, the the obvious problem is somebody there is always going to look more like, the most like the memory in the witness's head. Confirmation feedback, okay? After the witness makes an identification, police officer says, nice job, okay? You got it. Something to that effect, okay? You want to find out if there's any way to do it, what the officer said to the witness after the identification. Because when that happens, the witness's confidence goes right up. And now you're going to get that witness at trial who's going to go, I am 100% sure that's the guy. Okay? This is why they should be asking the witness, when the witness makes the identification, tell us in your own words how certain you are. Because it's a way of preserving evidence. Okay? You should in many ways think about this as trace evidence. Okay? Think about identification evidence as trace evidence. And like a piece of trace evidence, you have to collect it properly. You have to store it properly, right? You have to make sure it remains free from contamination, just like the witness's memory. So, was it collected properly at the scene? In other words, what kind of interview took place? I talked earlier about lots of questions about details. Okay, that's not proper evidence collection for that type of evidence. That right there is resulting in some contamination of that evidence. The same thing with confirmation feedback. You are tainting this piece of evidence because later on it's going to look much more certain when the witness says, I'm 100% sure. And proper procedure is to ask the witness right when they pick out the photograph, tell me in your own words how certain you are. Because that's a way of properly preserving that piece of evidence, the witness's level of certainty at the time of making the identification. There is some case law here from Massachusetts, and it's not that our case law is particularly great in this area, but we've had some recent developments. Commonwealth versus Silva Santiago was a case that came down 2 years ago, in which they said, yes, the police officer should be using these procedures, including asking about the witness's level of certainty. So, the law is really developing in different ways in different states. I think it's really important for people to do research outside their state and say, look, in Massachusetts, the Supreme Judicial Court has said that this should be the procedure that's followed. I realize that our courts haven't said that yet, Judge, but that should be the case, and this may be the basis for your motion to suppress. Okay. So what do we do about it? We have all this ignorance about all these various factors. What do we do about it? We talked a little bit about experts. Okay. Hiring experts, putting experts on the stand to educate the jury about this stuff. That is one thing that you can do. As has been mentioned, it is not easy to get these people. It may not be easy to get the money to hire them, or it may not be easy to convince a judge to let the witness, the expert, testify. But you've got to educate the judge about the specific factors and about the fact that this is sound science and that it is contrary to what our jurors know. Great case out of Utah. Is there anybody here from Utah? Shockingly, Utah is sort of, I think, on the forefront of this stuff. Their Supreme Court and has been for actually quite a long time. And just 2 years ago in this case, State versus Clopton, they recognized that cross-examination is not good enough. Okay, this is one of the things you'll hear from judges. You can cross on that. Okay, how can I cross somebody to show the jury that it's less reliable to make an identification of somebody who is wearing a hat? I mean, they're not going to know that. They're not going to be able to agree with that. But the real reason why cross-examination is not good enough is because cross-examination is designed much more to show a jury when somebody's lying than when they're mistaken. And so there's an excellent law review that talks about the fact that cross-examination is not sufficient to be able to educate a jury about these problems. And the Utah Supreme Court agreed with that in State v. Clopton. For years, and I'll talk about it a little bit later, Utah had the best instruction, jury instruction on identification. And in Clopton, they said, yeah, that was great, but it's still not good enough. And they didn't go so far as to say experts have to be allowed to testify in every case, but they came pretty close. I mean, they basically said, trial judges really should let experts testify because they need to educate the jury about these things that they just don't understand. So Clopton's a very important case. How else do we educate our jurors about it? Ask questions about it in jury selection, okay? And jury instructions. We're going to talk about those towards the end. Educating the jury through jury instructions, okay? Now let's talk about how you handle these cases, from arraignment through trial, okay? Just want to see how I'm doing on that. Okay, great. What are some of the things you want to do at arraignment? Any thoughts? Yeah, Mike?
Keep them out of sight,
Why?
so people don't confirm their previous ID by seeing the arraignment.
Okay, keeping your client out of view because there might be witnesses in the courtroom. And they may see him and say, yeah, hey, that's the guy. If they've already made an ID, this is confirmation and feedback. That's what it is. Yeah, oh, I got him. I must have been right. Right? Yep, judge is setting a high bail. I must have been right. Yeah.
Document close,
What's that?
document the close.
Yep. Before we get to that, I'm going to come back to that in a second. That's a great point. Quick story about this point, keeping your client out of sight. Last summer, I was called and asked to take an appointment in a murder case. The arraignment was going to take place in a small district court in a small town near Springfield, Massachusetts. And I drive out there. I'd never been to this court before in my life, so I didn't know any of the court officers. I didn't know the judge. I go down to the lockup. I meet with my client. He's wearing a pair of shorts, no socks, no shoes, no shirt. And I know that the media is there, ready to take pictures, put them on TV. And I don't want him to go on TV. I don't want him to have his photograph taken for two reasons. One, because he just looks guilty not wearing a shirt, you know. But two, I didn't know if identification was going to be an issue in the case. And one of the things I want to suggest to you is you should always assume that identification is going to be an issue, even if it doesn't turn out to be your defense. You never know, right? We don't have nearly enough information to decide on what our theory of defense is going to be. Identification is on the table, so we got to make sure we protect against the problems that we've been talking about. So I write out a motion asking to have his appearance waived. And I file it with the court. I go and tell the court officers. I say, don't bring him out into the courtroom. I'm asking the judge to waive his appearance. Fine, no problem, no problem. We're sitting around for a while. I still don't have the complaint, so we're not ready to go forward with the arraignment. And the court officer comes out and he says, the judge isn't going to let you waive his appearance because it's a murder case. She thinks he has to be in the courtroom. And I say, well, I don't agree, but I want to be heard on this, so please don't bring him out until I can at least be heard in front of the judge. Okay, sure, no problem. 10 minutes later, out comes my client with the court officers, without a shirt, click, 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 okay? And here's his picture that appeared on the front page of the newspaper and on the newspaper's website, video of him on TV. About a month later, I get the discovery in the case. Police report, statement from an EMT who was driving to the scene of the murder, called the first responder in the ambulance. She says as she was driving, she noticed a young shirtless kid riding his bike in the opposite direction about 3 o'clock in the morning. And when I saw the picture on the website, I recognized him. all right? Okay, 2 weeks ago or 3 weeks ago, I had a motion to suppress that identification. And that, it just should never have happened, but it did, and then I had to deal with it. So this shit can happen, right? So that's the first thing you want to do. Keep them out of sight. You know, it never looks good when the guy appears on TV with a coat over his head, but I'd rather that than an identification happening like this. So do what you can. Take off your jacket, put it over your client's head if you can't keep him out of the courtroom if there's media there. You can file a motion asking that the media not be allowed to take his photograph. Okay, they can be here, Judge, they can listen to it. My client's going to be in the courtroom, but they cannot take his photograph. We have a fairly progressive-minded new DA in this county who won election after this happened, and their office has now taken that position. Let's not take photographs in these murder arraignments, at least. Okay, here we go. You're going to document your client's appearance. Okay. What kind of clothes is he wearing? Does he have any scratches or any injuries that you want to take note of? We all now have cameras on our phones. So take a picture of your client yourself, or get your investigator there to take a picture. Preserve clothing. Yeah?
I have a question about that. Taking a picture on our phone, just logistically speaking, if let's say you can't get your investigator there and then you take it on your phone, how can you get that in? Because then don't you become a witness?
Well, get another lawyer to come stand next to you. Okay? I mean, you can put a lawyer on the stand and say, yeah, I saw him the day of his arraignment, that's what he looked like.
Okay, but you definitely need somebody else.
It's always, unless you absolutely can't find him. You'd rather take the picture and have to get off the case and have somebody else take it than not have the evidence preserved. But yes, you definitely want to try to have somebody else there. Okay, so preserve the clothing as well. You're going to begin to interview the client, and you got to be really careful about who's around. You don't want to do this if there's people around asking details about where he was, that type of thing. But if you can get privacy, find out right away, where were you? Okay, were you with anybody? What were you doing? What time? All that stuff, so you can begin to investigate. Okay, if you're in a place where you need to get funds to investigate, file that motion. File motions to preserve. Okay, you're not going to get this stuff, all this stuff right away. File a motion to preserve the 911 tape and the radio broadcasts. We call them turret tapes in Massachusetts. That is one of the most important pieces of evidence in an ID case, the radio broadcast, because that is probably the most reliable piece of evidence about what the description the witness actually gave. Much better than the police report, because what happens? The officer is standing there, interviews the witness, gets a description, and immediately radios it to all the other officers to be on the lookout for, a young white male wearing blue jeans and a white t-shirt, whatever the description is. That recording of that radio broadcast is probably the best piece of evidence about what the witness actually said about the perpetrator's appearance. The police report, that's written later when they get back to the station and they get shit wrong. Okay, so they can always wiggle out of that stuff. Surveillance video. Now everything's on tape, right? So what do you do about that? The best thing to do, I think, is to get over to the convenience store or whatever it is right away with your investigator and try to see the video yourself. Because if the cops haven't gotten it yet, you want to see it. Because if it's not helpful to you, we don't want to preserve that stuff. Right? There's your guy smiling for the camera. Clear as day. Okay. Nope, thank you very much for showing that to me. I appreciate it. You can keep it. I'm not taking that. Right? And you hope to God the police don't go and get it. But if it's helpful, you want to get it. And then you need to make sure it gets preserved. Sometimes they'll just give you some, store owner may just give you a copy. If they won't, get into court right away, file a motion for a court order that they must preserve that. Talk about that. Investigation, Okay, we're gonna begin to investigate right away. Get out there and interview the witnesses. Look for the surveillance tapes, as I just mentioned. Go to the scene. I cannot tell you how important it is to go to every scene in every case. But in an ID case, you need to look around and see what the lighting's like. You need to go there at the time of day that it happened too. Oftentimes at night. What is the lighting like? Is that light working? Is it not working? How far away is it? Distances, that kind of stuff. Did somebody really see well from this particular angle? So you gotta visit the scene, canvass the area to find out if anybody else, any of the neighbors see anybody. You may get somebody who saw somebody and gives a description that's different than your client. Okay, you want to begin to investigate an alibi, but other potentially helpful defense witnesses. And I'm now putting this as part of my slide on investigation. You got to start reading the social science literature that I talked about earlier. You've got to educate yourself about these factors. In terms of discovery, what should we be asking the state, the government to provide us? The 911 calls and the radio broadcasts. You've got to get that stuff. You want to get a list of all witnesses that were present at the scene, not just the two that are mentioned in the police report. You want to get statements of all their witnesses, not of all witnesses. Any witness who they took a statement from, you want that, whether or not they're calling that person to testify. So you need statements of your client, you need statements of the co-defendant. You need FIOs is a field, I don't know if this is something that's unique to Massachusetts, but some police departments do what they call FIOs, field interrogation and observation. My guess is they do this in other places. They basically just stop people on the street. Usually this is in poor neighborhoods, minority neighborhoods. Just stop people on the street and just ask their name, where you live, what you doing. You know, it's just kind of a way to hassle people on the street. But they actually document this stuff. They have FIO reports. They may do it where you live, you just may not know about it because you've never seen these reports. You want to ask for that type of report if that goes on in your jurisdiction, because they may have done an FIO of somebody around the time of the crime, and that could be a lead to a witness, or it could be a lead to the real perpetrator. Bless you. We're going to find out about what forensics were done. Okay, don't just, you have to ask, was fingerprinting done? Is there, give me the reports. Was there any DNA that was swabbed for? Want the reports, whether it was attempted or not attempted. You need to know this, because it's good stuff for cross-examination if they didn't do it. Also try to get the police rules and regulations and the specific training that this officer got. Lots of police departments now have regulations about identification procedures, as well as regulations concerning witness interviews. You want to get that stuff. That stuff can be dynamite for cross-examination because they didn't follow their own rules. This is Donnell Johnson, okay? Here he was on trial for murder, okay? Here he is years later when he graduated from high school after he was exonerated, after being convicted of a murder he didn't commit. His lawyers were not given statements that the co-defendant made that turned out to exculpate him. And that was what led them down the avenue, once those were discovered, to getting him exonerated. So not just your client's statements, but co-defendant statements too. What other information? You want names, dates of birth, addresses of any witness who attempted an identification. You may just get the ones that made the identification. You've got to ask for all of them. Other witnesses present. The manner of the identification procedure. Was it a show-up? Was it a lineup? Was it a photo array? Single photo? When did it happen? Where did it happen? Did they record the identification procedure? Some police departments are recording these now. You want to find out all statements that were made to the identification witness, by the identification witness, in the presence of the identification witness. Okay? Including the instructions, but not just the instructions. All statements by the witness as well. And any witnesses who gave a description. Maybe they never did an identification procedure, but they gave a description. You want to get that. If there's a photo array, you've got to get the color copy of it. How many of you get these like black and white photocopied photo arrays, right? Is that helpful at all? Right? No, you have to get what they looked at. And they're doing these now more on computers. And there may be computer records showing who looked at it, okay? And you know, potentially even how long they looked at it, that type of thing. And there's lots of forms and documentation in police departments that go along with these ID procedures. In Massachusetts is a case, Commonwealth versus Dugan, which says that you have a due process right to know about the identification procedures. So if they're not giving it up, you can potentially get a hearing, like a voir dire type of thing with the witness and the police officers, to be able to ask them all about all these details of the ID procedures. Okay, so now that we're collecting all this stuff, right? We're collecting information through our investigation, information from the state and through discovery. What are we going to do with it? Okay, one thing that's helpful is if you've got multiple statements by a witness, to make a chart showing this is how the witness described the person on this date, this is how they described him on this date, and this is how the witness now describes the perpetrator. And what you'll find is that description often changes over time. And usually, especially after an ID is made, it now becomes much closer to what your client looked like. So you want to chart out descriptions of witnesses. Think about what type of, as I said earlier, what happened at each stage. How should this have been done? What would have been the perfect way to do this? In contrast what happened with the perfect investigation. That always gives you something. Timelines are very helpful as well. I find timelines to be an invaluable way of organizing and understanding information. And sometimes theories of the case emerge because I'm looking at something that I've plotted on a timeline. Okay, I talked about this already. This is some of the stuff that you can do in the cross, right? You're establishing that they're careful to get an accurate description. They know that they want to catch the guy. The more accurate the description, or the more detailed the description, the better chance they have of finding the guy. And of course, you ask for all these details. And when we get the vague description, like we talked about earlier, that's good stuff. All right, that shows that the witness really didn't get a very good look. Okay, alibi. All right, alibis are really dangerous in ID cases, and there's been some good research on this as well. If you have an alibi that's not just utterly rock solid, you should think long and hard about putting on an alibi defense, because the research shows that an alibi that's a little bit weak makes it more likely that they're going to convict your client. Okay, it's some of the stuff that David was talking about in his direct lecture. You know, this is assuming a burden of proof. Right now, the question is, have you proven to us that your guy was here instead of there? And if there's any potential problem with it, you may lose, even though you had a great case attacking the reliability of the identification. Okay, so you got to know what your procedures are in terms of what you have to turn over and when. But wait until you've gotten everything from them, if you can, before you turn anything over. Because they'll change the date on you, they'll change the time on you if you come up with a good alibi. But you know, unless your client was like in jail, which seems like it wouldn't be a good fact, it can be a great fact. You've had that?
I did.
Yeah.
I did.
You did? Yeah, I mean, if you got a client in jail and you got records to show it, right, or you've got him on surveillance tape somewhere else at that time, be very careful about alibi defenses. One one of the dangers of putting on an alibi is having the witness impeached with the fact that, wait a second, you're claiming your buddy was hanging out with you at the pool, at the bar at that time, okay? And you knew he got arrested the next day, right? And yet you didn't go to the cops and tell them. This is the prosecutor's impeachment of your alibi witness. You didn't run to the police and say, wait a second, he was with me at the bar. You didn't do that? That's dangerous. Now, you should, in Massachusetts, there's case law on the foundation that they have to lay in order to be able to do that impeachment. No matter what your case law is in your jurisdiction, you should object to this. You should probably file a motion to preclude them from asking this. Why? Because it's really burden shifting. It's really saying you didn't provide evidence of your innocence. And that's really shifting the burden to the defendant to object on constitutional grounds to that type of impeachment. But also, talk to your witness, okay, about, woodshed your witness on this. Why is it you didn't go to the police? They may have a good explanation. Because I was beaten up by the cops just 6 months earlier, and I do not trust police officers. Maybe that's the witness's answer. It might not be a terrible answer to give at trial, okay? Especially if your theory has anything to do with attacking the cops. So woodshed your witness on that.
Have you prepared one of those before?
I've never put on an alibi defense. So, yeah.
That case said that if the witness had any reason not to go to the cops, it's barred.
What's that? A good, if there's a good reason why they wouldn't have gone to the police, then they're not supposed to allow them to do the impeachment. You may, if the answer is really good, then you may choose to let them do it, and then get up and direct. Can you tell them on redirect? Can you tell them why you didn't go to the police? If it's a great answer, maybe that's better than keeping them from doing the impeachment. Okay. Pass through some of this stuff. Motions to suppress. This is case law from Massachusetts, but there are various grounds in which you can suppress an identification. Not just that it was suggestive or unreliable. There's that's sort of the obvious one, but also if it was like on these show-ups, often it may be the fruit of a bad stop. Was there reasonable suspicion to stop your guy when they did? And if not, then the show-up is a fruit that should be suppressed. More and more, we're moving towards mandatory protocols they're supposed to follow in these when they do an ID procedure. And I think we should be arguing that the failure to follow the protocols means they shouldn't be allowed to introduce the identification. We haven't gotten there yet in Massachusetts, even though they've said they are supposed to follow these procedures. They haven't said failure to follow means suppression, but we should be pushing for that. Okay. We have case law in Massachusetts that even if there is no state action, an unreliable identification should be excluded. That was the basis for my motion to suppress the identification that was made of my client at his arraignment, whose picture was taken at arraignment. There was no state action. The police didn't do anything, but it violated common law principles of fairness was my argument to let in this this very unreliable identification. Okay. When you're thinking about how to try this case, think about all of the opportunities there were for mistakes to be made. Okay. What were the opportunities at the time of the incident for the witness to make mistakes? Whether it was the lighting conditions were poor, there was great distance, the witness was under a great deal of stress, there was weapon focus, all of those things that can contribute to the witness being mistaken, to the witness's memory being poor at the time of the incident. What were the opportunities throughout the investigation by the police for more mistakes to occur? What were the opportunities for a mistake to occur at the identification procedure? Okay. I had a trial where my client was, there was a very serious two guys were stabbed and robbed. They knew there were two perpetrators. They knew who one of them was. He was a friend of theirs, a supposed friend of theirs. and he was with a buddy, and they didn't know who that guy was. A few days later, one of the witnesses, one of the victims, comes to the police with a piece of paper with my client's name written on it. It says Geraldo Figueroa. And police go out, they find my client, they say, hey, would you mind coming down to the police station and have your picture taken so we can put it in a photo array? My client agreed to do it, comes to the police station, they take his photo, put it in an array, they show it to the witnesses, sure enough, they ID my guy. At the probation surrender hearing for my client, he was on probation, he had a 2-year sentence hanging over his head. One of the witnesses says, I saw his name on the photo array. Now, when you get the photo array, there's no name on it. But at the grand jury, when the prosecutor asks the police officer about that, the police officer says, no, his name wasn't on the array. What happened was, when I brought the defendant, my client, down, I took his driver's license from him, and I left it on that table where the photo array was. And I'm like, whoa, I got a defense now, right? I thought I was going to win a motion to suppress. I filed a motion to suppress. Sure enough, I lost, but once again, the police officer said, yeah, I did. I put it on the table. The reason I lost was because the witness claimed it was the guy who said he saw the name. He was gone. He'd gone back to Guatemala. The other victim, he was there, and he said, I don't remember seeing the name anywhere, and that was the basis for the judge's decision to deny my motion. But I still thought this is my defense at trial, right? They had the name. He knew the name because they had written it down on a piece of paper. Okay, oh, there's a driver's license with that name on it. There's a picture of that guy. Oh, there's the same picture in the photo array. Same guy, right? And of course, that's why I picked him out. Yet we get to trial, and on direct examination, the prosecutor asks the police officer, so did you have, tell the jury about this driver's license. But yeah, I had his driver's license. And I put it down, but I put it down on a table on the other side of the room. This was his testimony. Okay. Talk about having a fun time and teaching a witness. I mean, he testified twice under oath at the grand jury and at the suppression hearing that it was on the same table. I think he was just so embarrassed that he had done something so incredibly stupid that he couldn't admit it to the jury. So, of course, it helped me. The jury acquitted in 15 minutes. Probably because he so obviously lied. So, I don't know why I told that story. I was talking about opportunities for mistakes that happen during the identification process. That's kind of an extreme example. Post-identification statements, that's what I was talking about before. Anything that police officers say to the witness, anything that what does the witness say about his or her level of certainty at the time. We need to think about what is, our theory has to include some answer to the why question. Why did the witness mistakenly identify my guy? It's not just why could he have made mistakes, but why my guy? Why did he pick out my guy? I mean, I had a not very obvious explanation in that trial. Sometimes it's harder to find that answer. Is there something about your client's photograph that stood out from the rest? Sometimes you see these arrays where like one photo is like, the focus, it's much tighter, it's much closer shot than the others. It could be something as simple as that just made your client's photo stand out. And sometimes the explanation is he just looked the most like the guy who did the crime out of the 6 people in the array. Okay, who's the real enemy in this case? Okay, who's the cause of the mistakes here? Is it something the police did wrong? Is it something that some other witness did? In my case, it was the police officer, but it was also the person that, whoever it was that gave the victim my guy's name. So in that case, that information off the street was the problem. Who's the enemy in your case? Sometimes there's no real enemy, it's just that mistakes happen. We need to think really careful about language. Okay, what language we use when we try all of our cases, but in ID cases, there are certain things we need to be aware of. Okay, there are always more than 2 people involved. Okay, there is the victim, we're not gonna call him the defendant, but, you know, Mr. Jones, and there's the real perpetrator. And you always have to keep it separate. Here's the perpetrator, here's Mr. Jones. And you gotta be so careful when you're cross-examining the witness that you don't say, you know, when you saw Mr. Jones, you know, you gotta be so careful about what language you use. You have to keep these two people separate. All right? That's what I was just talking. You never want to say defendant or your client's name when you're referring to the suspect. And you should object when the prosecutor does. And look at the jury instructions very carefully. Make sure the jury instructions don't sound like the judge is saying that your client was the perpetrator. How are you going to refer to this? What language are we going to use to describe the perpetrator? Is it the stranger? Because that's nice if this was a stranger to the victim, right? And when the stranger approach is a bad word, right? When the stranger came up behind you, stranger is a nice word because it's communicating to the jury that this person that the victim had never seen the perpetrator before. The man you had never seen before is another way of communicating that. If your client's young, you want to use man. You have a question in the back?
Yeah, I just want to go back to the jury instructions, Tracy, to make sure it doesn't sound like the judge is making it sound like it's your client.
Mm-hmm.
What would be a way to, I mean, in the to convict instruction, if obviously it's got to name the client.
I mean, your client's name might be in there, but you want to look at when the judge is saying, like, one of the factors you can consider is the last time, is the amount of time the victim had to observe the defendant. Right? When the judge is describing the various factors that they should consider. Right? No, the victim never observed the defendant at all. So you want to look for stuff like that and object and ask the judge that is improper. And so, does that make sense?
Yeah.
Okay. The young kid, if your client's old, right? The big man, if your client is small, the man with bad skin, those things that didn't match the description of your client. That may be the way you want to describe the perpetrator, okay? The victim is a victim in these cases. We have cases in which we file motions in limine to preclude witnesses, prosecutors, judges from calling somebody the victim, right? If you're trying the Brown case, okay, she is not a victim because she wasn't raped. So nobody should be allowed to call her the victim. Okay, that violates the presumption of innocence. We're all presuming she is a victim. That really invades the province of the jury because that's what they're here to decide. But in these cases, this person really is a victim. And it's fine to call the person a victim. And in fact, you need to make it clear to the jury that you sympathize with what happened. What happened to this woman was a terrible tragedy. Something that no one should ever have to endure. She's simply mistaken about who did it, right? And the witness is mistaken in these cases. I mean, there may be ID cases where somebody's lying. You know, the Dodd case, obviously, Judy, they're lying. But the witnesses, the bank teller that picked out his photo from the array in Dodd, that person's not lying. That person is simply mistaken. Okay? Unless it's your theory that the person is lying. During jury selection, you may want to begin to introduce this theme of mistake. You want to get the jurors to talk about reasons why somebody might make a mistake. You think of any, we don't do attorney-conducted voir dire in Massachusetts, so I haven't thought very deeply about this. But you can imagine asking, can anybody think of a reason why somebody might make a mistake thinking they recognize another person? Well, they didn't get a good look, they didn't see the person for very long, they were distracted. You can generate good answers. So now you've got the jurors educating one another about these factors. You may also want to to those fundamental misunderstandings that I began talking about. What are those things that jurors don't understand? And I want to find out about those. Okay, because I want to either get those people off of my jury or figure out a way to educate them. And it may lay the groundwork for getting the expert on the stand. Judge, remember we asked those questions in voir dire, and it was clear that these jurors think